Okay, perfect. All right, we're recording now. So let's begin. All right, perfect. So we're going to start with the first part of business law. So the first thing we need to know is, what is business law actually? Well, guys, business law, it's just enforceable rules of conduct that are going to govern commercial relationships. So it's basically, how can we make sure that everything is done ethically and correctly between two different businesses? So let me give you an example. So there's different types of law. The main type of law in business is going to be contract law. So let's say, for example, I own a company that makes, here's my fob for my building, for example. I own a company that makes fob for buildings, right? And let's say I do a contract with an apartment building in Boca Raton. I don't know an example of one. Let's say the Palmetto, right? So let's say I own a company called Key Fob Manufacturing, and I make a deal with the company that owns the building. So I'll supply them with 100 of these a month or 50 of them a month for existing and new tenants. So in that guideline, right, we're going to have certain compliance standards that we need to hold to, certain payment procedures, whether we have to pay on a net 30 basis or net 60 basis, along with quality assurance for each and every single one of the pieces of fob that we supply to the building. So business law, all it is, we're just making sure that we're acting ethically and that everything that we promise to do is going to be delivered upon in writing. It's as simple as that. It's the best way I can describe it. Okay. So next, we have private law. So private law is regarding disputes between two entities. So, for example, in the case that I just mentioned, let's say the company that owns the building is called Palmetto Management Group LLC, compared to my company, Fob Manufacturers Inc., right? So any dispute that we might have or any contract that we create is going to fall us, since we're two private entities. We're not individual people. We're owned by entity structures, which is a limited liability company and SRC corporation. So because of that, we have legal protection, and therefore it falls under private law. So private law, in a nutshell, is having two independent entities, so two private entities, either in a dispute with one another, or they create a contract with one another. So the difference with that, and in the textbook it says, for example, if a store owner is delinquent in paying rent, the dispute is governed by private law. So let's say I own my business and my landlord is Palmetto Management Group LLC, right? If I am late on my payment for my warehouse to them, that's going to fall under private law, since there are two private entities in that complaint. So because of that, it's private law. That makes sense, guys?
Yes.
Okay, perfect. And if I move too fast, just let me know. We just have to cover as much material as possible. And then public law is just going to be between people and its government. So let's go back to Palmetto Management Group. Let's say Palmetto Management Group owns a building, but they're not following Florida environmental regulations. The Florida, whatever the agency is called in Florida, let's say it's Florida Environmental Agency, they can sue the limited liability company, Palmetto Management Group LLC, for not following for following environmental standards. And as a result, they can file a lawsuit and a complaint. That would go under public law, because it's regarding a government agency and a private entity. So that can be private entity or individuals in public law. So let's say, for example, I own a home in California, right? California has much stricter environmental laws than here in Florida. Let's say my house does not follow environmental laws. The government can sue me because I am not following California environmental standards for the home that I own. So that would be an example of public law. So the big difference, private is between two entities, typically an LLC or corporation. Public law can be between an individual person, LLC, corporation, versus its government. I gotta admit someone in. Hold on one second. Okay, perfect. That should be good. Okay, perfect, perfect. So that's the difference between public law and private law. One's between two entities, one's between an entity person versus their government or regulatory agency. So civil law, so this is the third type of law. Civil law is going to lay out the rights and responsibilities implied in relationships between people and between persons in their government. So this could be disputes between two people and their government. So let's say two people file a complaint against a regulatory agency for being too harsh on a certain regulation, or let's say a government agency or a publicly owned government-owned hospital committed medical malpractice on two families, right? The two families can sue that hospital that's owned by the government. That would be an example of civil law. So that's going to be between people and people and their government. So public law is just people and individual entities versus government or regulatory agency. Private law is between two entities, typically a limited liability company or an S corporation or C corporation. And then civil law is between two people, government. So, for example, let's say two people, let's say you own a dog, right? Let's say you own a vicious Rottweiler. I'm just putting it out there as an example. And your Rottweiler attacks my dog. Let's say he's a small little pug, right? I can sue you for damages against my pug, right? So that would fall under civil law because it would be between two individual persons. So that's the difference between private law, public law, and civil law. Does that make sense, guys?
Yes.
Okay, good. Perfect, perfect. And then criminal law here, so that's going to regulate situations in which someone can act against the public as a whole. So criminal law is going to be between someone that commits an offense against the public of the state. So that can be bribery, mail fraud, wire fraud, could be battery. It's basically a crime in which not an individual person necessarily is in danger, but the public as whole is endangered. So let's say instead of, I don't know, let's say, for example, I own a business and a lady comes in and she's irate, she's really mad, and she punches one of my employees. Not only could I sue her, but also she would be arrested. Let's say it happened in the state of Florida. She would be arrested because she is causing malice to the public. As a result, not only I could file a lawsuit, but she'll also have a case against her, an indictment against her. That would be, let's say the lady's name is Susan. So we would have Susan versus the state of Florida because she committed an offense against the public. So the difference between civil law, public law, private law, and criminal law. Public law typically involves disputes, lawsuits, civil cases. Criminal law is going to be more serious crimes that cause issues towards the public. So that would be like hitting somebody or committing wire fraud or committing insurance fraud by burning your house down. There are a lot of different types of criminal law, but it just causes malice to the public. And it's not between an individual person typically. And then we also have cyber law. So that is pretty much just the basic law that we have, common law, that's going to be based upon usage of the internet. So what's included in cyber law, have you guys ever tried to go on a YouTube video and it says this video is banned in your country or this video is banned due to copyright reasons? Have you guys ever had that?
Yes.
Yeah. So in cyber law, right, people hold what's called intellectual property. We'll go over intellectual property in chapter 12. But people will hold individual property, such as intellectual property. So that can be music, that can be a brand name. Typically, music is copyrighted. So if you wonder why someone's video got demonetized or a video can't be up, they likely violated some type of copyright and they couldn't upload the video due to copyright infringement. So that would be an example of cyber law here. Mhm. And then we have statutory law. So all this is, so it's basically guidelines that are written into the United States Code when they're passed by Congress. So it's a collection of all laws in one convenient location. So different states, that there are going to be different jurisdictions. We're going to go over jurisdictions in a bit, but statutes basically provide a guideline to city and county laws. So for example, let's say you want to, let's take a look at the example here. Let's say you want to open up a donut shop, a Krispy Kreme in Santa Fe, New Mexico. You can't open that in your house because your house is zoned for residential use. It isn't zoned for commercial use. So some states will have different zoning laws and where you can put a principal place of business, right? So for example, in this, you need to be able to know, okay, the materials you can use. Some states might have stricter environmental regulations in their statutes. So due to that, you might be able to put one type of material in one state, but not another type of material, not the same type of material in another if it's banned in the statutes. So pretty much it's just a guideline to local and state guidelines. That's pretty much all it is. So you need to follow zoning where you can put it, materials that you can build the location with, and your minimum wage guidelines as well, how much you can pay per your state statute. So it's just guidelines of how to operate in business in state municipalities and local municipalities. Okay, and model and uniform laws is very similar, just suggestions for statutory law at the state level. So, for example, like we said in the previous example, a lot of states are going to have a lot of different regulations. For example, in the state of New York, I actually found this out. When you start an LLC, you have to do a publication in a local paper, which costs up to $1,000 in the state of New York. In the state of Florida, you don't have to do that. You only have to do a filing fee, which is around, I think, like $120. So that would be an example of a different statute, where in New York, you have to file within a newspaper and do a publication for your LLC. For Florida, you don't have to do that. So that would be different. So because there are so many laws that need to be followed, there are going to be model or uniform laws that are suggestions that suggest what should be implemented for statutory law at the state level. And this results in what we call the Uniform Commercial Code, or the UCC. So basically the UCC, it just establishes, it's basically the constitution of business law and commercial law. So it establishes guidelines and guidelines in order to conduct business ethically and correctly within the general United States. Okay, does anyone have any questions, or I can keep going?
I'm good. I think you can keep going.
Okay, perfect. Okay, and then cases. So laws are going to be seldom self-explanatory. So case law / common law, that's going to be a collection of legal interpretations made by judges. So the best way I can describe this as, let's say, for example, we have two previous cases involving the topic of abortion, right? And let's say we had two judges interpret it a certain way, ruling in favor of the defendant. We would continue to rule in the favor of the defendant in a similar situation. So that's where we get into precedent, which is using past decisions in similar cases to guide later decisions. So an example of that would be using a ruling in the, let's say, for example, I don't know if you guys remember Brown versus Board Education, right? When they declared separate but equal with the segregation of schools in Alabama. So what they did there was, in that particular case, they used the ruling in Plessy versus Ferguson, which established that precedent, saying that the schools could be segregated as long as they were equal. So because of the decision in Plessy versus Ferguson, they did the same for Brown versus Board of Education, where they continued the precedent of separate but equal until the law was changed as a whole, where the schools were put together and it was outlawed to segregate them based on race. So precedent is just using past cases to determine what you should do in the present. Okay. And then we have stare decisis. So this is basically a ruling made in higher courts that becomes precedent for lower courts. So the Supreme Court made the ruling in Brown versus Board of Education, right? So with the Supreme Court, since the Supreme Court made that ruling, now that applies to the lower courts. So the court in Birmingham, Alabama, the court in Huntsville, Alabama, the court in Decatur, Alabama, right? So stare decisis is when a higher ranking court, the Supreme Court or the federal court, results in a decision that lower courts need to abide to. Just give me 1 second here. Okay, perfect. Okay. And then, and the example here would be Roe versus Wade. If we see here in 73, so the court decided that the fetus is viable, the woman can terminate their pregnancy. So the decision was upheld in 1992. And then it was also, so it was upheld in 1992 based on this previous precedent. So even though it was Planned Parenthood of Southern Pennsylvania, right, which is more of a local municipality, the ruling in the Supreme Court with Roe versus Wade applied to that more local case because it's a higher ranking court and therefore used stare decisis. So the difference precedent is just the general of using past cases to determine what you should do in the present. Stare decisis is having a higher court make that ruling to be used in a lower court. Okay, and then we have restatements of the law. So that's just summaries of common law in a particular area. So it's very straightforward. They're just interpretations of the law in their case. It's pretty straightforward. Like, for example, courts in one jurisdiction are not going to need to obey precedents in other jurisdictions, but you might be influenced by them. So let's say, for example, we had a ruling in California, but we're a judge in New York, but the ruling in California made a lot of sense for us, or the details in the case are very similar to the case that we're facing in New York. We might use the president in that case to make the decision or state, even though it's a different jurisdiction. Okay. And then administrative law is just law from different agencies such as the Securities and Exchange Commission and the Federal Trade Commission. So that's pretty straightforward. Like, for example, I don't know if you guys watched The Wolf of Wall Street, but Jordan Belfort was not only fined, but arrested by the FBI and the Securities and Exchange Commission for pump and dumping penny stocks. So as a result, that fell under administrative law because the Securities and Exchange Commission, which regulates trading of securities, stocks, bonds, and other types of securities, found out that he was participating in fraud and they arrested him for it. So that would be an example of administrative law. And then treaty is pretty straightforward. I think everyone knows what a treaty is. It's basically between two states or international organizations. Executive orders, it's just issuing of directives. So for example, Franklin Roosevelt, when he did an executive order to put German people and Japanese people into internment camps, while people of German descent and Japanese descent into internment camps, that's an example of an executive order. Okay, and then we have the type of law, so statutes, administrative law, here common law. And then natural law is just what we believe is moral. So let's say, for example, I don't know, Mariana, let's say you just got your paycheck from your job, right? Now, if I have no morals and I'm thinking for myself, I'm going to take the money because, well, I need money to pay for my bills. I needed to pay for rent, food, etc., right? But my morals, because I know that you worked for that, will not let me take that. So that's what we mean by natural law. It's just doing things that we believe are morally right. Go ahead.
Oh no, I thought you were gonna ask me something, so I was ready to answer.
No, you're all good. You're all good. I was just
Okay.
using it as an example. That's all.
Okay, got it.
Got it. And then legal positivism. Sorry about that. It's just our proper role as obedience to authorized law. So it's to pretty much followed the law out of respect for society. That's pretty much what it is. So natural law is just for morals. Legal positivism, I can't say that, is basically to follow the law for the betterment of society. And then identification with the vulnerable is following the law based on people who are not as fortunate as you. So we would look into fairness as example. So let's say, for example, minimum wage. People need to be able to make a certain livable wage in order to be able to afford their bills and expenses. So that would be an example of identification with the vulnerable, when workers should be paid a minimum wage. That way they can survive. And then we also have historical school, which is similar to president. All that is just following behavior of people who faced similar problems in the past. So it's very similar to president. And then we have legal realism, where judges look at more just the law. They also look at social and economic conditions. So an example of legal realism, I don't know if you guys watched the documentary, but the O.J. Simpson case, when he was accused of murdering his wife at that time, Nicole Simpson. So not only did the decision in that case and the controversy surrounding it, it didn't just affect OJ, it affected the United States as a whole. So, for example, the trial was very publicized, the evidence was publicized. So the decision in that case that was made would not only affected OJ himself and the defense and the victims of the crime, but it also affected the United States, because now we've seen the publicization of other cases as well, such as Bernie Madoff in 2008, with him doing one of the largest, or I believe it was the largest Ponzi scheme in American history. The George Zimmerman case that happened, I think it was around 10 years ago. George Floyd, which was more recent, all of you should know about. So the O.J. Simpson case, based on the concept of legal realism, set the stage for the next. It changed how socially we view cases. Okay, and then we have sociological jurisprudence, which is basically seeing other legal perspective as mechanical, that they wish to obey universal rules of legal reasoning. So we see legal realism as pragmatic, but you have to remember that certain judges, they might view laws as changing. They might be more progressive. So as a result, they might change their interpretation of the law based on that concept. Some judges might not be so rigid. And then cost benefit analysis is a guide to legal change. So this just sees the maximized benefits and the minimized costs. So let's say, for example, I want to make a law that, I don't know a good example. Let's say we make a law that is going to yield more cost to us than benefits. Let's say it'll be hard to convict someone of this crime, or the loopholes might be too much. It might not even be worth it for us to move forward with it, because it's just going to take too much for us in order to put in that justice. Therefore, we should not use it. So that would be an example of cost benefit analysis. So, for example, polluted land is going to be an economic loss, because we can't use it for food and we can't use it to drink water. So because of that, the price of the environmental cleanup is going to cost way more than what the land might even sell for. So because of that, there makes no point for us to file a complaint against it or have some type of lawsuit. Okay, and then constitutional law, pretty straightforward. It's just the general limits of powers the governments have in their written constitutions based on the constitution of that specific country. Now, note, not every constitutional law is going to be the same. Let's say, for example, the United States versus North Korea, they're going to have two very different types of constitutional law systems. You know, one of them is Juche law, which is the North Korean legal term. It's called Juche. And then you have the United States constitutional law. So both of those are going to be extremely different. So that's chapter 1. Now we're going to move on to chapter 2. So ethics, it's pretty much just the study of practice of decisions, what's good and right. So ethically, right? Let's go back to the example with Mariana, right? Let's say I want to take her money because I needed to pay my bills. Now that is not going to be ethically right because she worked for that money, and that's not right for me to do that. So because of that, we're going to use ethics in this case to determine what's good or right. And ethics need to guide us on what we're going to do in each decision. So business ethics is applying those ethics, but in the business world. I know that sounds kind of redundant, but let's say, for example, do we want to make a decision that's best for our company or best for society as a whole? And that's going to lead into what we call an ethical dilemma. So that is a problem concerning what a firm should do where there's no clear right choice. So for example, I'll do a local example. I don't know how many of you guys are local, but for example, the Parkland shooting with Nicholas Cruz, right? This happened, I think, 5 years ago now, maybe 4 years ago. I don't remember exactly what it was. But in that case, right, let's say on Nicholas Cruz's cell phone, he wrote note, like he used the Notes app, hypothetically. Let's just put that for a scenario sake. And he basically planned out his entire attack and all his victims in the notes of his phone. Now, the FBI, if they know the evidence, there might be evidence in his phone, they might request to be able to hack into his phone. Let's say Mr. Cruz has an iPhone, right? Now, Apple, who owns the iPhone, the company that produces iPhones, they make an obligation to their stakeholders and shareholders to have protection of privacy, right? So we have an ethical dilemma. Do we want to be able to have evidence to present in a court of law to gain solace for the victims and to convict Mr. Cruz of the crimes and to prosecute against him? Or will Apple not be willing to give that up in an obligation to its shareholders and stakeholders? So an ethical dilemma is when ethically we might need to do something, but that doesn't fit our direction as a company. So that would be an example of that. And then we also have social responsibility of businesses. So all that is getting involved in the community, different types of charity work, different types of donations, but also, being active in social justice. Like, for example, companies doing Pride Month promotions or businesses getting involved in charity events. That would be an example of the social responsibility of businesses. Now, not every business owner or entrepreneur or executive believes that businesses have an obligation to the community. For example, Milton Friedman, he argued that the only social responsibility of businesses is to increase its profits, meaning that they don't have social responsibility. However, in the modern world, that's definitely changed. Let's say a company, let's say the UFC, for example, right? The UFC is more of a conservative-based company with Dana White. I'm personally a big fan of the UFC, but that's not anything related to his politics or any of that. But let's say, for example, the UFC, they've denied advertising of 200 million, 250 million because they didn't agree to be socially responsible based on the politics of the advertiser. Or another example would be, so this happened around 10, 11 years ago with the sports team. So the owner of the Los Angeles Clippers, his name was Donald Sterling. He was a very successful real estate mogul. Mr. Sterling was known to be a little bit racist, and then there were recordings that came out about him of saying racist things about some of the fans at his games, and because of that, sure, he might have been able to make the Clippers a profitable team, but socially, considering the fact that the majority of his players on his team were African American, and the team was in a league that was African American, because of that, there's a social responsibility there, and a lot of advertisers that were paying him money pulled out of their advertising deals because of Mr. Sterling's antics. So that would be an example of social responsibility of business. It's just maintaining societal norms and standards, but also being involved in social activism to build more goodwill for your business and society. That's all it is. And then here, for example, we look at AIG. So AIG was one of the largest insurance underwriters in the country before the 2008 stock market crash with the housing crisis and mortgage-backed security crisis. So AIG operated very unethically because they paid $165 million in bonuses 2 days before the bailout. The problem was not necessarily paying the bonuses. It was paying the bonuses that people didn't deserve it. They paid bonuses to people that put AIG in the mess that it was in to begin with, because what AIG did, they insured mortgage-backed securities for large investment groups such as JP Morgan Chase, Goldman Sachs, Lehman Brothers, which ultimately collapsed and was bought out by JP Morgan. So that's where AIG made a huge mistake by insuring a lot of securities in the housing bubble. And as a result, they basically crashed and had to be bailed out by the government. And also there was a huge outrage because they gave the people who messed everything up for them and caused that bailout $165 million in bonuses. So that shows the society that this business, they're not very ethical. They don't really care. They just care about their executives. So that caused a huge reputation problem. And that's another thing that happens when you don't get involved in the community. You can really hurt your reputation as a firm. And that's where social responsibility of business really kicks in. With the Clippers example, with example of certain businesses like Chick-fil-A, how they don't condone homosexuality, how some people won't do business with Chick-fil-A because of that. That would be another example of social responsibility of businesses. And then besides social issues, there's also moral issues. For example, certain countries, the government controls the means of production. So certain businesses might not want to pay the government bribes in order to use supplies. This was an example when McDonald's opened in Russia. The franchises only wanted to receive supplies from foreign providers. That way they didn't have to pay any bribes to government officials. So that would be an example of staying ethical within business. Okay, let me scroll down. So we have two different types of decision making. We have the WH process of ethical decision making, and then we have ethical guidelines as well. So we scroll down, right? We have the W, which is the who, right? So who is this going to affect? This is going to affect our customers, number one. Our customers are most important in a business or a job. In a job, you have to work for your boss. In a business, you have to work for your customers. Your customers or consumers are the most important people in your business because they are responsible for money coming in. Number two is going to be the owners or investors. Okay, so the owners of the business. Let's say you're a publicly traded company on the New York Stock Exchange. You need to keep your stock price up. That way your investors continue to make money based on the money that they gave you during your IPO or the issuing of your common stock, right? You also make a commitment to your management. Make sure that your management is paid on time. Make sure that they are able to manage the company effectively. How will your decisions affect management and their reputation? And also, how will it affect your employees? Will let's say you make a decision that's not ethically well or not within social responsibility, and as a result, your reputation goes down as a business, and then you lose money. When you lose more money, you might not be able to pay your employees. So you might have to lay some of them off in order to maintain profitability. So because of that, a decision might affect your employees. And then it can also affect the community as well. As we said, the community might not agree with certain ethics of yours. And as a result, they might not shop or buy product from you. And as a result, you might lose money. So that would be the effect on the community. And then future generations. Pretty self-explanatory. How is your business going to be remembered by future generations? Is it going to be like AIG, where even though they had years and years of making billions and billions of revenue a year, they're only remembered for their 2008 stock market crash because of greed? They're only remembered for that because it takes a long time to build a great reputation, but it takes an instant to ruin it. And then we also have the how. So public disclosure, universalization, and the golden rule. So we'll go down, right? So that will be lower on. But here are some examples of stakeholders. So owners, employees, customers, management, community, and future generations. These are people that make a commitment to that business or firm. Okay, so values is pretty easy. It's what a company believes is good or desirable. So what I value is, I don't know, let's say, for example, what Microsoft values. They value providing good software to consumers and businesses, being ethical and maintaining profitability. That would be an example of their values. Okay, and then we have some of the business ethics. So we have justice, which is to treat all humans identically. All these examples here. So you have efficiency, which is to maximize the amount of wealth in society, to get the most out of a particular output and to minimize costs. Freedom is to act without restriction from rules imposed by others, to possess the capacity or resources to act as one wishes. And security, possess a large enough supply of goods. You guys get the picture here. And then here's an example from IBM. So you have to respect your consumer, provide good service, try to live the best way you can, lead effectively, make an obligation to the people that hold your stock, be fair to your suppliers, and be a good corporate citizen. So the golden rule, guys, I think we all learned the golden rule. Treat others the way you want to be treated. Pretty much standard. Then we have the public disclosure test as well. So for example, let's say right here, we have Walgreens, right? Let's say Walgreens releases publicly that they illegally handle and dump pesticides, bleach paint, pharmaceutical waste, and other items, right? Now, let's say instead of doing that secretly behind closed doors in the boardroom, they release that to the public saying, hey, we are going to disclose this publicly, and if there's an outrage about it, we won't do it. So because of that, if Walgreens were to do that in that situation, not only would have they avoided the $16.4 million lawsuit, but they also would have been more favorable in the public eye. So that would be a benefit of a public disclosure test. And we also have a universalization test. So not only is this going to affect the public necessarily, but this affects everyone as a whole. So for example, you might think, okay, let's say I make a decision in the business. Let's say I want to take a $800,000 hard money loan to buy a building, right? I have to think, do I want other people, future CEOs of my company, future executives of my company, would I want them to do that same exact thing in my situation? That would be an example of a universalization test. Would you be proud of that? Would you want your company to do that in the future before you make a decision? That would be an example of the universalization test. So that's chapter 2. Okay, well, we do have some theories. So we have ethical relativism. So this is just a denial of the existence of objective moral standards. So all this is, we believe that morality is relative. Thus, no one can criticize another behavior as immoral. So some societies, right? Let's say, for example, in North Korea, we believe it's immoral to be denied the right to immigration. In North Korea, you're forbidden to leave the country. In North Korea, it's not seen as not moral to do that because that's the culture there. That's the law that they have set in North Korea for over 5-6 decades. But in the United States, that's unheard of to deny people exit to the country. So that would be an example of ethical relativism going in place, because we can't see each other's behavior as immoral due to different cultures. Just let me check one thing. Okay, I got people in here. Okay, perfect. Okay, and then we have situational ethics. So this is just going to evaluate morality in different types of situations. So it allows us to judge people's actions, but only specific to that situation. So let's say, for example, a company has to lay off 5 employees because they're losing money or their revenue went down over the past 6 months. Due to that, right, we maybe in that situation, we would think, you know what, they did the right thing. But as a whole, if we think in terms of the people that got laid off, now they're out of a job. So we have to kind of relate to the situation and see, okay, was this the right decision to make for the business or for the people? All right. And then we see absolutism. So this is just deferring to a set rules and decision-making process. So it's not subjective. It doesn't depend on perspective. We're just following the book in absolutism, no matter what. We follow the book. That's it. And then we also have consequentialism. So that's making decisions based on future consequences. So let's say, for example, let me think. So let's say we want to take out a loan of $3 million to get some new equipment and pay our staff, right? Now, the consequences of that, let's say the equipment doesn't work as advertised or brings us the profits that we expect. The consequence of that could be our investment not paying it off. And as a result, we might not be able to pay our loan and then we could go into default. Well, consequentialism, we're basically saying, okay, what are the future consequences that are going to be relevant to our stakeholders, employees, future generations, shareholders, and our customers. And then utilitarianism, all utilitarianism is just make a decision based on who's going to have the greatest pleasure. So, for example, you have to look at, as a whole, as a company, which decision is going to be best for the majority of the people. That's what we're looking at in act utilitarianism. And it would be the same thing for rule utilitarianism. So that would be for everybody. So the greatest amount of pleasure for all involved should be established and followed in each situation. So I actually made a mistake. So act utilitarianism is going to be all the potential actions in each situation, and we need to choose a situation that is the most amount of pleasure over pain for those involved. So there might be some pain, but we need to provide the best case scenario. Even if we're not going to get the best case, we need to provide whichever scenario is going to be best for all parties. So it's similar in that aspect to rule. And then we already went over cost-benefit analysis. We have deontology, which is on the basis of recognition that certain actions are right or wrong, regardless of consequences. So let's say, for example, someone has terminal cancer. Now, we look at it ethically. Firing someone when they have terminal cancer is a really, really crappy thing to do, right? But the firm has an obligation to shareholders and employees, right? If that employee can't produce, they have to be dismissed. So that would be an example of deontology. It's basically acting on the basis of a recognition that certain actions are right or wrong, regardless of consequences. So even if we lose money, in terms of our current culture in the workplace, we might have to keep that employee just to maintain our culture. Okay, so I'm going to keep moving. Okay. So let's do chapter 3, legal system. So jurisdiction basically means where the law applies to one person. Hold on one second. Someone's trying to join. Okay, perfect. We got 9 people in here. Okay, let's keep going. Okay, so they should be able to join now. Okay. So we have jurisdiction. So for example, if I commit a crime in the state of Florida, let's say I get a traffic ticket in the state of Florida, right? The jurisdiction that's going to be applied to is the state of Florida because I committed the crime there. So the first thing we have is trial courts, or courts of original jurisdiction. So that's just the power to hear and decide cases when they come into the legal system. So the parties are going to present their evidence. They're going to call witnesses to testify. So this is just a common court, right? It's just the local court, let's say Palm Beach Court or the court in Broward. That would be an example of a trial court, right? So that is where the initial complaint is taken. Now, let's say after the initial complaint, right? Let's say the verdict has been decided, the case has been dismissed, or the plaintiff has been ruled in favor, and the defendant must pay damages. The losing party, whether it be the defendant or the plaintiff or the defendant in a criminal case against the state, can go to the appellate courts. So if they believe that their trial was unjust or the evidence didn't make sense, they can go ahead and request for an appeal and review the evidence. That way they can try to get their decision reversed. So that would be the purpose of the appellate courts. My father worked in the appellate courts in Brooklyn. So he had a lot of experience with people who were convicted of a crime, who might be in prison, who might be, maybe in a commercial litigant case, but it was typically in prisons where this happens, where people would appeal. So a criminal or a convicted felon would appeal their case if they believed that it was unjustifiable or the ruling was not in proportion to the crime that was committed. So people can file an appeal in order to get their sentence commuted. So a court in which the case is going to be originally held in is the court of original jurisdiction, and then the court where it's appealed is the appellate jurisdiction. So in personam jurisdiction is going to be the court's power to render a decision that's going to affect the rights of specific persons in the court. So basically, this is just the jurisdiction in the state. So if I commit a crime in the state of Florida and I live in the state of Florida, I'm going to be under in personam jurisdiction. So we could also do, so in personam jurisdiction can also happen to out-of-state defendants that have a certain minimum contacts in the state. So let's say I live in Pennsylvania, but I own a business here in Florida, and my business does something unethical. Let's say I have contacts in the state of Florida. Even though my company might be registered in the state of Pennsylvania, I would still have to follow and be under Florida in personam jurisdiction. So in personam jurisdiction, we have the plaintiff. So the plaintiff is the person that's going to be filing the lawsuit. So let's say we have two different parties, right? Let's say we have, again, let's go back to our example with Fob Manufacturers, Inc., and then Palmetto Management Company, where I sign a contract to supply them with key fobs for their buildings, right? So let's say I'm suing the, let's say, for example, I'm suing Palmetto Management Company for being 40 days late on a payment that was supposed to be paid in 30 days on my accounts receivable, right? And I'm suing for damages, right? Because I want to get my money, because I could run into cash flow problems, might not be able to pay my workers, cost of goods sold, right? So in that case, I would be the plaintiff because I'm suing. And therefore, Palmetto Management Company, the company facing the crime or the case, is going to be the defendant. And then what will happen is a complaint will be filed. So let's scroll down. There should be an example of a complaint somewhere down here. There'll be an example of a complaint down here. So a complaint will be, okay, I'm going to list out a specific. Okay, so in the contract, we said that my company is supposed to be paid every 30 days for each shipment that we put in of the key fobs. And then in the complaint, we can also outline the defendant has breached the contract by being 10 days delinquent on a payment, right? So that would be an example of a complaint. And then the summons is going to inform Palmetto Management Company, hey, there's a lawsuit being filed against you for these specific reasons. So we'll file a complaint, and then the court will deliver a summons through service of process, which is the procedure in which the courts are going to give the documents. So they'll typically use through personal services, where an officer of the court's going to hand summons and the complaint to the defendant. So the defendant will have an opportunity to review the complaint and then make a defense for themselves. So let's go here to a long arm statute, right? So let's say, for example, let's say I service another apartment building. Let's say in Oregon. Let's call it, I don't know, Oregon Management Co. Limited, right? Oregon Management Company. Let's say we're running into the same issue where they're 10 days late on a payment based on our contract that we created. Some people might try to evade legal action by leaving the state and remaining outside its borders, but states also have long arm statutes. So that's going to allow us to file a lawsuit in the state within our jurisdiction. So we can file a lawsuit within the state of Florida based on Florida law to a corporation or an individual person in our home state. So that's what the long arm statute's able to do. Let's keep going down. And then we also have, so to review that, in personam jurisdiction is having a lawsuit that is under, or a criminal case that is under the jurisdiction in which the crime or contract dispute occurred. And then the complaint is what happened. The summons is telling them, hey, this is what the plaintiff is suing you about. We wanted to notify you this is happening. Scroll down. We also have a very specific type of jurisdiction. It's called in rem jurisdiction. So let's say, for example, I own a Utah company. I don't know. Let's say my company has a plant in Utah manufacturing these fobs, right? And let's say I have a company in Idaho, apartment building, or let's say someone owns a very small building. 1 second. Say someone owns a small building that won't allow them to, let's say they're not paying me for my fobs. Instead of suing them directly, I can say, hey, in order to alleviate for the damages, I want to go after the building, and if I win, we get to sell the building and keep the profits in order to fulfill the money that we lost based on the lack of payment. So basically, we can force someone, if we win the case, we can force someone to sell the property in order to pay us off. And that would be an example in the state of Idaho. So you can do that, go after a property in order to pay off a debt or a short-term liability. So subject matter jurisdiction, this is going to be states' power to overhear certain kinds of cases. So, for example, an appeals court, we're not going to take that to the Supreme Court. We're going to take it to an appellate court. For a traffic ticket, we're not going to take it to family court. We're going to take it to traffic court. So the subject matter jurisdiction allows us to be able to have specific courts for specific types of crimes and infractions. So we see here, we have exclusive federal jurisdiction, which is going to cover federal criminal prosecutions, bankruptcy, state for state conflict, patent and copyright claims, right? So that's strictly under the federal jurisdiction. And then we have state jurisdiction, which is just going to be all cases not falling under the exclusive federal jurisdiction. And then we have our concurrent, which is federal question, citizen, and diversity of citizenship. Okay, and then we have the legal principle here. So we have our concurrent federal. So this means that the state and federal courts have jurisdiction over a case. So the state of New York and the United States of America court could have jurisdiction over a case. Okay, so let's say we have a Florida campaigning financing law that violates the First Amendment. Because it raises a federal question, it will be under concurrent jurisdiction. So it's directly combating or going against the First Amendment, which is under the jurisdiction of the United States Supreme Court. So because of that, we're not only going to have an issue in the state of Florida, but the United States as a whole. Okay. I want to get through this. We have 5 minutes left. And then a venue, pretty straightforward. It's just which trial court where the case is going to be held. So let's say I commit a crime in Green Acres. The venue of the case will likely be West Palm Beach in the courthouse. Okay, and then we have federal trial court. So here's this little chart here. So the United States Supreme Court's the lay of the land. We have the United States Circuit Court of Appeals, and then we have district courts, bankruptcy courts, and then we have all these different types of courts here. So you see patents and trademarks, court of federal claims, tax court. So each court is going to have a specific need for certain cases. And then we have the court of last resort, which is the Supreme Court. So on the rare occasions where it needs to happen, if there's a dispute so big that the Supreme Court needs to settle it, it'll be the last resort in order to settle a particular case. Okay, and then we have standing. So all standing is, we need to prove that there has been some type of personal injury or issue that has affected the plaintiff. So I can't sue somebody. Let's say, for example, my neighbor has a dispute with a contractor over a payment, right? I can't sue the contractor on behalf of my neighbor. I can't do that. So because I have no standing. The person that is affected must directly sue or file a lawsuit against the party that has caused some type of harm or some type of effect to the plaintiff who's filing the lawsuit. And then there's also ripeness. So ripeness is how recent did this occur? This has had to have happened immediately. You got to file a lawsuit immediately. Now, let's say I have the same dispute, but it happened 7 years ago. I can't file a lawsuit over something that happened 7 years ago because it's not ripe. It hasn't happened recently, so it just doesn't make sense. So a case has to have some form of ripeness before you can file a lawsuit. And then we also have a case or controversy. So there must be a controversy. Argument, a complaint, something like that. If there's no case or controversy, why would you even sue? Just to sue? There's no point. Your case is going to get thrown out in the court of law. Okay, and then we also have steps in litigation. So we have informal negotiations. So this would be a discussion or negotiation between two parties. This can happen in arbitration, something of that nature. Typically, arbitration is very big, so the two parties can try to settle before it becomes a lawsuit. This is very common, and it can even be detailed in contracts. And then we also have pleadings. So let's say arbitration doesn't work, or the two parties cannot come to an agreement, and the case actually does come to a lawsuit. So we will have a pleading stage. So the attorney for the plaintiff is going to initiate a lawsuit by filing a complaint that we mentioned earlier in the court, detail what happened, and then the lawsuit begins. So the attorneys are going to prepare arguments for each side's claim. So the defendant's attorney and the plaintiff's attorney. Okay. And then we can also have a default judgment. So if, let's say I file a lawsuit against a tenant because they didn't pay their rent for the last 2 months. If they don't respond to me or respond to my complaint, I can motion to file a default judgment, which basically means that the defendant has failed to answer the complaint and the facts that I'm stating supports the judgment. So if I want to evict them, they haven't paid their rent and they just haven't answered me or they're blowing me off, I can ask the court and say, hey, I want to file a default judgment. So let's say they do respond or no default judgment is needed, we then get an answer. So an answer is going to be the defendant is going to affirm, deny, or claim no knowledge of the accuracy of the allegations. So there's an example here. So in first defense, we're going to admit to the allegations here. We're going to deny the allegations here, and then without knowledge to 7, 8, and 9. Okay, and then we also have a motion to dismiss. So let's say if the defendant believes that the allegations are true and that there's no way that they're going to be able to defend themselves, the defendant can file a motion to dismiss. That way they don't have to go into the whole lawsuit, and that way it's easier for all parties to settle. So they can file a motion to dismiss the case. And then After this, right, or let's say the defendant also has a claim against the plaintiff. Let's say the plaintiff did something bad, they can do a counterclaim stating that, hey, the landlord said we could do this, or the landlord say, hey, you're good for this month. The defendant can put a counterclaim, or the tenant can put a counterclaim in that example. And then if the defendant files a counterclaim, the plaintiff's going to file a reply. So the reply is going to be the answer to the counterclaim. So it'll be similar to this. So they'll say, no, let's go down. So they'll do something like this as well. So here's the counterclaim, and then they'll answer to this counterclaim. And then we'll have a motion for judgment on the pleading. So this is pretty much for the court. They need to consider the facts of the defendant and the plaintiff as well. If the court grants the motion, the only reasonable decision is going to be in the favor of the moving party. And then we also have a motion for a summary judgment after the discovery process. So after we find out the facts, let's say there are no factual disputes that exist, right? Our favor is going to be in favor of the moving party. So the difference between this is that the party may use affidavits, which is going to be a sworn statement from the parties or witnesses, documents, depositions, and interrogatories. Interrogatories, excuse me. So I mentioned the word discovery. So discovery is just finding new facts and details regarding a case. That's going to be presented to the jury in the court of law. And interrogatories are going to be written questions that one party is going to send to another to answer under oath. So let's say, for example, each party needs to answer certain questions about a particular contract or dispute. That would be an example of an interrogatory. Sorry, I mispronounced that really badly. And we also have the request to produce documents. So let's say we have a contract dispute with a lease, right? We need to be able to produce documents. Hey, produce the lease agreement, produce the lawsuit, produce the contract that was signed. These are documents that we need to produce, right? And then we're also going to have a deposition. So we're going to both have a copy of the testimony. We're going to provide the details of what happened, and if there are any discrepancies, then we might not have great credibility. And then we can also have an admission of facts. So we have an admission of documents, which is the request to produce documents. Now we have an admission of facts that we're going to admit or deny. So we can admit, hey, the landlord said, oh, the landlord said we didn't have to pay this month, or the landlord can deny that. All right. And then we also have a pretrial conference. So this is just going to be between the attorneys and the judge, just to discuss the legal issues, the factual issues, and to possibly work out a settlement. That way we can avoid litigation. And then we also have voir dire, which is just the jury selection process. And then we also have preemptory challenges, which is just going to be challenges of the number of potential jurors giving a reason. So, for example, let's say, we want to eliminate an ethnic group because we believe that might be biased. That's going to be a preemptory challenge. Okay, and then we also have mock trials, which is just, for example, we'll have the jury kind of simulate how the case is and listen to the arguments and testimony. That way we can see how the jurors would approach a case to make sure that they're going to be a fair jury. And then a shadow jury is not going to be the actual jury, right? So we'll match the demographics of the actual jury, but it'll allow us to test run and simulate and see how people of a certain demographic are going to respond to the same case that we're going to have an actual jury for. Okay, and we also have a directed verdict, which is just a motion to direct the verdict for the defendant. Even if the jury is going to accept all evidence, right? The jury might not have legal base for a decision in favor of the plaintiff. So let's say, for example, right, we have the same case, right? Let's say we have evidence proving everything. We were able to disprove that the defendant, we never told the defendant that they couldn't pay, right? It was a big lie. We could go ahead and motion a directed verdict to prove our innocence and to win the lawsuit. Okay, and then we also have a prejudicial error of law. So that would be a mistake so significant in a case that it's going to affect the outcome. So let's say we messed up a part of the evidence or we tampered with evidence. That would be a prejudicial error of law. And then we would put that in what's called a brief. So an appellant, let's say a criminal, let's say the evidence in the case was mishandled or tampered with, we can file in the brief, hey, my evidence was tampered with, and therefore I want to file an appeal against my case due to my case not being fair due to tampering of evidence, and then prove that in the brief. And then we also have a writ of certiorari. So this is just an order to the lower court to send the Supreme Court a record of the case. So this is very rare that it happens, and it's really only going to happen when a federal question is raised, usually an amendment that's said in the Constitution. Okay, so that's pretty much it for the first 3 chapters, guys. I know I went through as much as I could. If you guys have any questions, I'd personally recommend for more specific examples to sign up for a specific session, for an individual session with me. They will be available this week, and if you haven't already done a session with me, the first one is free for this class due to the amount of material. I highly recommend doing an individual session this week, just because this exam is worth so many points. If we don't do good on this, I'll just be honest with you, it's going to be hard to pass the course. So I recommend doing an individual session. Apart from that, that's pretty much it. And does anyone have any questions before I sign off?
No, thank you.
Perfect. No one else. Everyone's all good.
Yes, thank you so much.
Perfect. Okay, guys, sounds good. So anyone that wants to sign up for a session, let me know. I highly recommend it due to the stakes of this exam. So appreciate it, guys, and I'll see you guys on Wednesday. Take care.